So we'll start with the impeachment proceeding. So for this, I wouldn't go too detailed, as in I've provided the essay sent in the WhatsApp group. So for impeachment proceeding, the particular sections you need to pay attention to will be 155 and 145 of the Evidence Act 1950, and also the 113 sub 2. Okay. So in regards to the procedural rules and all, you can actually read up the essay which is shared in the group. It can be used in both evidence, your evidence paper, and also the criminal procedure. So if you get to read that up, you can use it both ways. Okay, so I'll be covering the summary trials today. First of all, when someone is arrested, okay, he is charged. So this summary trial actually lays out the whole procedure, okay, from pre-trial conference up until sentencing. So first of all, let's look at this pre-trial conference. What is pre-trial conference? It normally happens only between the PP and also the defense counsel. So meaning to say that the court is not a party to pre-trial conference. It's only between the PP and the accused counsel. In short, this pre-trial conference, it is to for both parties to meet up, as you can see here, to identify the factual and legal issues, to narrow down the issue of contention, to clarify each party's position, because the PP might have a different position, which as a defense counsel, you wouldn't know. So the PTC is actually for both parties to sit down and to understand. And also discussing the nature of the case, and also the 51A, meaning that the PP should actually provide the documents prior to the trial, okay? Okay, so the next would be all matters agreed upon by parties must be reduced in writing, signed by the accused or defense counsel and DPP, yeah? So this pre-trial conference would normally not take place when the accused is not represented by a lawyer. Moving forward, we have this case management. So in this case management, what the parties will do is actually similar to the case management in your civil procedure. So at the case management, it involves the court, DPP or PP, and the accused or the defense counsel. As mentioned earlier, for the PTC, court is not involved, but for the case management, the court will be involved. So in short, during this case management, as mentioned earlier, if the accused was not represented by a lawyer, right, so you wouldn't have PTC. So the issues will be discussed during CM, as you can see here. Yeah. If there is no pre-trial conference held, then all parties would have to discuss the matter in accordance with 172A during the case management. Okay, so in short, this case management is to set down the intention of the parties with the involvement of the court, and also the trial and hearing date and so on. Yeah. Okay, so the next would be plea bargaining as per 172C of CPC. Previously, the old CPC doesn't contain this plea bargaining. This plea bargaining was actually what we call that, it was adopted from the Indian CPC. So, okay, as you can see, during this plea bargaining, actually the PP or the defense counsel will actually put forward something. For example, there are two methods of doing this. First would be to reduce the charge. Second would be to reduce the sentence, meaning that to remain the charge and reduce the sentence. Take, for example, someone is charged with 39B, but probably the drug is borderline. So they could actually consider, okay, to reduce to 39A. And if the accused actually agrees with the 39A, he or she would need to sign something, would need to reduce to in writing, as you can see here, in Form 28A. he or she will need to sign the form to prevent what, some accused would be say, okay, I will plead guilty, but subsequently the accused refused to plead guilty. So to prevent that to happen, see, everything is written, must be written. Okay. So some might be asking, what are the advantages and disadvantages? As you can see, the advantages would be to reduce the backlog of cases lah, because there are tons of criminal cases going on every day. Some are very minor, some are very major. So that to save the court's time, you can actually do plea bargaining. And for plea bargaining, normally the court would be very lenient, quite lenient, except for heavy cases or major cases. For this, I wouldn't go into detail. So, okay, what does major cases mean? As per the definition, will be any cases which carries a sentencing of more than 10 years imprisonment. So that's how they actually define heavy or major cases lah. Okay, so for this plea bargaining, some might also be asking, what is the sentence which is going to be passed by the court? First of all, as per the case of Christopher Koo, right? Is it correct? If not mistaken, Christopher Koo. Normally, 1/3 will be reduced. The sentence, the imprisonment, 1/3 to be reduced lah. However, keep in mind that the court has a discretion to pass any sentence as well. Yeah. So the disadvantages will be to pressure the accused lah, because you are now offering something, and some might not want to go through the hassle of trial and so on. So they might just plead guilty lah, even though they are not guilty. Okay. So this is plea bargaining. Okay. So after plea bargaining, if the accused accepts the plea and pleaded guilty, so the next will be having a charge here. Okay, so this charge, I believe Dr. Chee later will cover some of the charges, which is like joinder and all the elements like that. But however, do keep in mind one thing. Okay, the purpose of the charge here is for the accused to understand what offense have I actually committed. Okay, the keyword will be read and explained here. Okay, see, there's one case, just a minute. Okay, for the case of Fong Siu Po, yeah, it was held that if there is more than one accuser, each charge is to be read separately and explained to each accused. You cannot having 3 persons charged together and you read only one charge. If there is a separate charge, you should read to each and every of the accused. So this charge part, nothing much. So keep in mind that the keyword will be read and explained. Okay, so what happens when an accused plead guilty and not guilty? So some might be thinking this flow is actually a bit complicated, but don't worry. You just flip your CPC, section 172 and 173. The whole procedural flow is there. So in the event, if you sort of forgotten the sections, don't worry, keep calm. During the exam, just flip 172 and 173. You can see everything there. So without further ado, this pleading guilty, okay, once the charge is read and explained, the accused is given a chance whether to plead or not to plead, plead guilty or not guilty, yeah? This one actually, I believe everyone is well versed, meaning you plead guilty, then the court will actually proceed with sentencing. Then you put forward your mitigating factors, whereas the prosecution will be putting forward the aggravating factors. If you plead not guilty, then of course you have to go through the trial process. Okay, so after the plea, you will have this issue of prima facie. So what is prima facie? Prima facie is actually, you can think it this way, it's on the surface, meaning that looking at this, before being called into the defense, whether the elements and the facts put forward by the parties could actually, on the surface, amounting to the person being guilty or not. So, looking at the surface, if the court feels that, okay, they finds that there is a prima facie, okay, as you can see, as per the section of 173H Romans 1, if a prima facie is actually established, the court shall call the accused to enter into his defense. Okay, prima facie, only then defense. So, if this accused is being called to enter defense as per 173H8, this one, don't worry, flip your CPC is in it. The accused can actually give sworn statement, unsworn statement, or remain silent. So do keep in mind that if you give sworn statement, of course, there's more weight to be placed on the statement. And if you give unsworn statement, what is the difference? The difference would be you cannot be cross-examined. See, if the accused give unsworn statement, he cannot be cross-examined. Yeah. So as per 257 sub 2 of CPC, if the accused remains silent, there shall be no adverse criticism. So in your exam question, this might comes out, meaning that, okay, this accused is in the dock and he refused to say anything, and the court probably draws some adverse inference against him. So you should invoke 2572. And if the accused choose not to give a sworn statement, he cannot be cross-examined. This one keep in mind. Okay. So 173H Romans 2, if a court finds that the prima facie has been made out on the offense other than the offense charge, the court shall amend the charge. Okay. However, do keep in mind that the court's duty is not to amend the charge. It's not to amend the charge. Later, we'll come to the case law. Okay. And section 158 provides that if you amend a charge, the amended charge shall be read and explained to the accused. This one is very common sense. If you are putting a charge towards me and now you're amending the charge, of course, you have to read it again and explain it again to me. Yeah. So some are illiterate probably in the court. They only know one language and so on. So they should find an interpreter to actually explain the whole thing again to the accused and ask him whether he plead guilty or not guilty. So the process will actually repeat. Okay. And when the defense has closed its case, so it comes to decision. Okay. When it's guilty, then you put forward mitigating factors, then the prosecution, as usual, put forward aggravating factors. And if not guilty, then will be DAA, discharge amounting to acquittal. Remember, this one is not DNA, it's DAA. If it is found not guilty. Okay, so I believe we have covered summary trials. So I believe Dr. Chee will cover this part, trial part, right? So I'll pass to Dr. Chee. Just a minute. Stop sharing.
Are we going to talk about the High Court? No need, right?
Yeah, just
actually it's almost the same almost the same. It's only that maybe I can add on a little bit. The High Court trial with the summary trial. Summary trial actually is the trial process for session court as well as your magistrate court. The High Court one, I think the differences will be the consent of PP must be first obtained before you can have any trial in High Court. That's number one. And second thing, I think the difference would be the PP must make its opening address. That means to say, PP need to address to the court, dengan izin, Ya Arif, so and so. This is the trial regarding to what we call about one section 39B case, and we are going to tender the evidence, and these are the witness lists that we are going to call. So this is how you introduce. There's no formality here, but I think these are the brief differences that you must know. And bro, you want to share the slide or I share? I share. Huh?
You may share. Yeah, you may share. It'll be
I share.
easier. Yeah,
Can see,
yeah. Can. Yeah.
can see, so,
Mm.
okay, just wait, I need to- Okay, so, Mr. Gan had talked about weakness, so I will
Bro, just
talk
1 minute. I think your slide is not sharing. Share again.
now.
Yeah, yeah.
Now
Can
better.
see now. Yeah, yeah.
Okay, there are several issues pertaining to the trial itself. Lah. For example, the weakness. Okay, the weakness part is like Mr. Gan had said to us, PP was started calling his weakness. That means PW, the prosecution weakness. So PP actually has probably a long list of weakness, but at his discretion, he only need to tender or call the witness that is so-called maybe favorable to his case lah. Okay, he'll give probably out of 10 witnesses, he'll call 5 major witnesses. Okay, that is his discretion. And then the court cannot say no towards that particular prosecution witness. Okay, and the witness, the remaining, for example, another 5 witnesses, if he has it in his hand on the list, but he's not calling them during the trial, you must remember that it must be given to the defense counsel. At least the defense counsel knew about the existence of this witness. Otherwise, the adverse inference under your Section 14G of Evidence Act could be invoked. It will pass a presumption in the court that the prosecution only call the witness very favorable to his case and hiding the rest. Okay, the concept now you must remember. Okay, this is the first point in regards to calling witness. The second part will be pertaining to recall witness. Recall witness means the trial is already ongoing. TW1 had gave his examination in chief, being cross-examined and re-examined already by the prosecution and also the defense counsel. But subsequently, can we recall the PW1 when we have reached maybe the day of trial, we reached already PW5? The answer is yes, but subjected to certain situation. This is particular when the charge, suddenly PP changed the charge. Okay, instead of I charge you for theft, I now charge you for gang robbery, for example. The whole thing changed, right? So the accused will be able to call the PW1 who had undergone all the EIC, CE, one more time, because the strategies arranged by the defense counsel. Take, for example, you are the defense counsel. You will ask different questions about the gang robbery rather than the theft in the previous charge. Okay, not so hard. Okay, this part. And PP also has the right to call witness for the same purpose. That means the PW1, the prosecution witness one, probably had to subject to the whole 3 process lah, examination in chief, CE, RE, 2 times. Okay, it is allowed. Okay, and also the court, you must remember, the court is a place where the justice is served, whereby in the scenario, the PP did not call the witness, or the defense counsel also miss out the witness. Actually, the court has the right to summon and also to examine the witness, for the interest of justice. So this is under your section 425 CPC. Okay, you just briefly know about the provision. Okay, if it comes out in exam, you just briefly say, do not copy, just briefly say based on your understanding. Okay, but the section must remember, and demeanor of witness. Demeanor of witness means the conduct of the witness, in the court. Take, for example, you have a murder case, you have a direct eye witness. Okay, we call it prosecution witness 2 lah. Okay, he witnessed the whole murder. Okay, but he's sort of giving evidence like not very confident, keep touching his nose, look away from the judge, because during when we give examination, I mean the witness, we have to look at the judge. So the judge will assess every single small conduct. You smirk, you smile, suddenly you like that. These are the demeanor that will be recorded by our judge, for the purpose to assess the credibility of the witness, whether this person is lying or not, in a very simple term, whether his words are accountable and could be relevant or credible to be assessed by the court. This is the small thing that the court can jot down in the notes. Okay, the judge can jot down. This is pursuant to your section 271 CPC. Okay, and pertaining to witness part, we can also have expert witness. Okay, this one is pursuant to your section 399 subrule 1 CPC, as well as you must cross-refer to your section 45 of your Evidence Act. Take for example, there is a condition, usually who are the experts that usually the court will summon? It will be chemist in the drug case, okay? Second, forensic pathologist in murder case. And sometimes you have those gun murder case. You will be called those kind of ballistic expert to assess gunshot residue, okay? In your clothes, for example, I found some gunpowder on your on the accused shirt. So this is where the expert witness shall set in lah. Okay, so the court actually allow it, and this is the procedural provision for expert witness. Okay. So next we have defense of alibi. Defense of alibi is provided under your section 402A. Now we do not need the 10 days requirement. So long, okay, alibi is not raised by accused. It's not raised by prosecution. Usually raised by the accused. So there's a need for you to distinguish, I think I have commented a bit in the group, the bare deniers as well as the alibi. The alibi simply means the accused was in a very different place, geographically different, the time also different, and the space that he's having, it's not possible for him to commit certain crime at that material time and space where he claimed he is. Okay, for example, I'm in Johor. I could not have been possible to commit murder case in KL right now, because now I'm giving talk here. You all will be my alibi, So how do I admit you all? Will be under section 402A. And this is a very strong defense for the accused, whereby the PP must be given sufficient time to investigate the legitimacy of defense of alibi. Means I have to give you give PP the list who is attending. From what I see is Mr. Gan is here, Shanta is here, so Ching is also here. So you all will be named and then PP will call you. Hey, are you sure you attend the class with Chee tonight? This is how sufficient time is the key. Okay, you can use the case of Kulip C, or this PP, according to Reynolds note here, will be PP against Lim Chen Len here. But the concept must be right. Before you cite authority, the case law comes later. Cite the proviso first. Okay, proviso first. And next, okay, what happened during trial? Adjournment. Adjournment is favorite. I mean, from the case of our Najib, you can see a lot of adjournment have been ongoing, either by our judge who is declared to be sick on MC, or even COVID suffer from the accused suffer from the what we call the witness also got. Okay, these are the reason of the court can actually grant adjournment for a hearing of a case. Okay, so this is provided under your section 259 sub rule 1. And one more important thing, okay, every time the court adjourn the case, will means the KPI, the key for performance index of the court is dropping, because the court actually they have certain guidelines as well. They need to finish the case. They cannot drag the case like 10 years, 15 years, not moving. And that case will be hanging in the mind of accused for too long, also not nice, isn't it? So they will need to jot down the date of each adjournment. The grounds must be recorded. This is under your section 176 sub-rule 2 sub-rule OCPC. So everything is documented. Who is, for example, I am sick. Next time Mr. Gunn is sick. So it's all on mark, Next time I cannot like use the excuse I got sick again, the court will refer back. Hey, how many times you want to get sick? I mean, these are the possible feedback that you may get from the judge if you use the excuse too often. Okay, just for the purpose of delaying the justice, okay, for the client's interest, okay. And submission of no case to answer. Okay, submission of no case to answer, it is when the prosecution finished his case. Meaning, when the prosecution already finished calling his witness, tender all the necessary evidence to the court, okay, before the court held any prima facie case, okay, the court usually in practice, this is nothing to do with your provision, in practice, will ask the defense counsel, okay, and invite them informally. They'll ask, okay, defense, you have anything to say? You want to make a submission of no case to answer. Okay, this is by the case, I think is Lee Kuan Yew here. Okay, Lee Kuan Yew, you must remember. This is a courtesy from the court. You they will not make submission of no case to answer, meaning I will enter defense. I'll leave it to the court to decide whether prima facie case or not. Then I'll choose whether to enter my defense or not. Okay? If there's a plain and obvious case that prosecution witness pun tak dapat, evidence pun tak ada, then you can confidently say, I will make submission of no case to answer. Then the case finished lah. I mean, prima facie case also cannot be made out, finished lah. Okay, this is the one point here. I think you should know. And part heard case, okay, part heard case is like this. During the trial, sometimes too many witnesses will be called. Okay, we take the example of our ex-prime minister case, 20 over witnesses have been called. So it cannot be finished in one day. Okay, sometimes, okay, today is a trial, tomorrow is a trial, and then subsequently, next week will be the trial for the list of witnesses that we could not finish, PW1, 2, first day, 3, 4, second day, subsequently next week, 5th and 6th prosecution witness. But what if in between, the magistrate got transferred, got promotion, or got transferred for some reason? Okay, so this is considered a part heard case because the judge, the magistrate himself already marked down the demeanor of the witness, and also he writes something in the notes of evidence already. So takana somebody new has to come in and give his whole opinion because he only referred to whatever written by the previous magistrate, So you must take note that, okay, actually, section 261 CPC, the accused may, in the interest of justice, the defense counsel can raise this thing. I want to call all the witnesses, the PW1, PW2, yes, had been heard by the previous magistrate, but the case had been now heard by new magistrate. I want to recall everything. I want to do it the whole set again. So there's no prejudice here. Okay. But sometimes in the event that the magistrate is just switching the place, for example, from Johor Bahru to Kulai, if logistically arrangeable, the same magistrate from Kulai can go to JB to continue finish his case. That will be a better solution. Okay, and in the event whereby, because magistrate session court judge they all under the roof of Attorney General Chambers, AGC, Judicial Legal Service umbrella. Sometimes magistrate got promoted, but not to become a magistrate or session court judge. They can become promoted to be a DPP also. So this is whereby conflict of interest can arise because the case is charged by DPP against the accused. But now you have an old magistrate that promote to be DPP. Usually this sort of case, it is best for that old magistrate to avoid. Okay? Because sometimes you can argue there's a miscarriage of justice because conflict of interest. Now, the DPP and also the the old magistrate who had been promoted to be TPP, they come to hear this case. So conflict of interest. Okay, please remember that. And compoundable offense. Compoundable offense, I think you need to refer to this what we call the column 6 of your first schedule inside your penal codes area. All got whether this case can be compounded or not. Compounded means just pay money pay money to the court without being subjected to imprisonment. Okay, so this is provided under your section 260. Okay, compoundable offense. And you have here is all three first convict. That means acquit. Okay, nobody shall be trial for the same offense whereby he was previously convicted or acquitted. Okay, meaningful to say, today I steal mineral water in 7-Eleven Jalan Kulang, for example. I steal it. Okay. And then I got convicted for 1 year imprisonment for stealing this mineral water. Okay. After I got released, because there's abuse of power or anything similar like that, can I be retried or charged again for the same mistake? The answer is no. So this is provided under your section 302 CPC, and also the procedure is provided in section 303. Please remember that. Okay, this is like double jeopardy lah. You cannot impose double jeopardy on a particular accused. But let's say, for example, if I steal today, I steal 1 mineral water, okay, in the morning. But afternoon, I go to the same shop again. I steal another chocolate. Then tonight, before I give this class, I steal another sugar cane. Not sugar cane, just the M&M, the chocolate. Again, I love chocolate. So I steal 3 times. The story will be different, Even though I convicted for the mineral water part, I can still convicted for chocolate as well as for the sugar. You get what I mean? So get that in mind lah. Get that in mind, And okay, unsoundness of mind is interesting. Unsoundness of mind is actually a good defense. How to say? It's not a good defense, but it is a usually raised defense in the court practice to cast doubt on the mens rea issue, mental state issue. I mean, I do not have the intention to commit crime. Okay, take for example, I stab a gun with a knife, and unfortunately, he succumbed to that particular attack. Okay, so I can claim that I was crazy when the time I stabbed him. Okay, this is first scenario. Unsoundness of mind at the material time you committed the offense. Second thing, when what we call the judge asked me to plead guilty, I also can pretend that my material time during guilty plea, I don't know, my smile, I pretend I don't know how to work it out, but I keep smiling to the judge, appear to be unsoundness of mind. So whatever guilty plea, the court will not accept, because that time my mental condition is not competent to plead. Okay, get that Get that? And we have a series of procedure lah. Section 342 until 352 CPC, the medical personnel will set in, the medical officer, the psychiatrist will set in to give you certificate, to certify that you are actually pretending, you are fabricating your unsoundness of mind. You are fit to plea. Okay, so this sort of thing. Okay, you must remember lah. Okay, unsoundness of mind. Anything I miss? I think that's it. Okay, so this is
Yeah,
interesting thing that have happened during trial lah. Particular issues that you must take note with. All right.
thank you so much, Dr. Chee. Very entertaining talk lah. So yeah, okay, so I'll continue with my this CFC lah. Okay, can see Hmm. Okay, so we will go into this course for children. See, okay, course for children. This one, I'm not sure whether you would like to answer it in the exam, but keep in mind that if you're answering course for children, right, you need to memorize a few sections. Okay, of course, it's under the Child Act 2001 lah. So this Child Act 2001 came into force on this August 1st of August 2002. So this one no need lah. You don't need to explain it in the examination. However, subsequently you need to define what is a child. Okay, for most of the acts, just remember section 2 would be definition. So you can just put section 2. If in case you forget the subsection, it is totally fine. You just say that a child is defined in section 2 of the CA 2001 as a person who is under the age of 18 lah, okay, but attain the age of criminal responsibility, because anyone who is below 10 years old, the mens rea is not there, meaning that they cannot be found guilty for any offense. This one keep in mind. So some will be asking me as well, okay, for example, this Child Act, okay, we are actually opening a new question here in your examination. So should I actually repeat Child Act, Child Act, Child Act? Actually, no need. Okay, for every new question, you just write Child Act here, 2001, then just in kurungan, CA 2001 is sufficient. So subsequent, you just write CA 2001. This saves your time as well lah. Okay, so as per section 12 of the CA, the court for children would actually sit either in a different building or room from other sittings, meaning that, for example, Mahkamah A, B, C, or 1, 2, 3, but this one is probably in another building, okay, or room, meaning that it is usually not together with the crowd lah. But due to the courtroom situation nowadays, it's actually just right beside, just that they will clear the audience, they'll clear everyone who is not related lah. So they clear everyone out and start their proceedings on different days, meaning that they will probably set a date which is has less cases. It's not together with all the other cases lah. If in the same premises where other courts, the court shall have different entrance and exit. This one, unfortunately, sometimes it is not practiced, but for the sake of examination, you may mention this lah. So this is under section 12 lah. Okay. So for the investigate, arrest, search and seizure, this one we usually wouldn't go into it. So what happens if the question is asking about investigation, arrest, search and seizure? I will not suggest you not to take up the question. Okay. If it is asking about the flow, okay, the trial at this CFC, cause for children, then it's fine that you attempt the question. I'm being more practical here because we do have limited time and we do not want to waste any of our precious time. Okay, so for this jurisdiction, okay, pursuant to section 11, so now you only have a few to remember. The first would be section 2, how do you define a child, right? Then subsequently section 12, you have different exit, yeah, on a different day and so on. Now you have 11, okay. So section 11 says that can try all the offenses except those which are punishable with death. Okay, so this CFE is actually a magistrate's court. You see here, consists of a magistrate. However, it shall be assisted by 2 advisors, and 1 out of 2 of the advisors must be a woman. Okay, so meaning that there'll be 3 persons, like you can imagine, you should visualize that. Magistrate and 2 advisors, left and right. So 1 should be the woman. Yeah, if you think about it this way, so you can remember it better. Okay. Okay, so this one is the frequently asked part. A bit tricky, you must keep in mind. Okay, just now we had 2, 11, 12, right? So now we have 83. So everything is actually in 80 something to 90 something, the sections we are using hereafter. So, okay, you see, section 83A, 83 is 1, sorry. Yeah, so if the offense is committed by a child, but charge was only made when he attained the age of 18, what happens? So, the case shall be heard by a court other than CFC, meaning that he'll be heard in a normal court. Okay, why? Because, you see, a person committed at the age of 16, for example, and he was only charged at 18, due to probably he escaped and he was only arrested when he was 18. So he was deemed to be not a child at the age of 18. So it will be charged in the normal court. This one is as per 83 sub 3. Don't worry if you forget the sections, it's totally fine. You just say as per section 83 of the Child Act. Okay, don't need to crack your head about these sections. As long as you know the principles, sufficient. Yeah, sufficient. So if a child is charged jointly with an adult offender, meaning that they have a few, some cases I've ended before is like they have a few drug cases. So some are 15, some are 16, some are 30 over. So they are actually charged in the adults court, meaning the normal court. Is not in the CFC because the adult cannot be in the CFC. Okay. So what if, for example, he was charged at the age of 17 and the trial drags on, now he is 18. He will continue to be heard in the CFC. It counts from the date of charging the accused. Okay. So this one, nothing much here. So you should remember these 3 things. The first one would be the offense committed, but only charged when 18. This one, it should be heard in the CFC. So charged jointly, not in the CFC, attains the age of 18, not in the CFC. Okay, clear enough, yeah? So we move forward to the bail. Okay. So for bail, section 84, just not 83, now 84. Okay, everything is actually within 80 something, 90 something. So provides that if a child is arrested, he shall be brought before the CFEC within 24 hours. So this one is actually the same as CPC. Okay. The next 84.2 provides that if it isn't possible to bring a child before CFC, he shall be brought before magistrate who may direct the place of detention. Because you see, the word magistrate is not magistrate's court, you see, meaning that he shall be brought to a magistrate. It's not necessarily in the court. It can be in front of a magistrate will do. Okay. The next, section 84 sub 3 provides that CFC shall inquire into the case and shall release the child on a bond with or without sureties, unless that the child actually committed something which is grave crime, murder, or necessary to move the child from associating with any undesirable person or defeat the ends of justice, meaning that it might cause some injustice. And other than the above mentioned, the bond is usually given. Okay, a bond is usually given. Okay, this one nothing much as well. So, okay. This is frequently asked as well in your exam, meaning that the trial process, just like I mentioned, if they ask about seizure, they ask about arrest, then you may think of probably avoiding the question. But if they ask about trial process, you see, just now we have 83, 84, Now we do have 88. So it's relatively easy for you to memorize, yeah? Okay, section 88 sub 1 places a moral and legal duty for the parents of the child to attend CFC unless CFC is satisfied that it is unreasonable for them to attend. Okay. Failure to attend, the parent is liable to a fine of 5,000 ringgit or imprisonment or both. This one, if you remember, write it. If you couldn't remember, it's totally fine as well. Okay. So what is the rationale behind? Let's think logically. Of course, this child is actually under 18. So when he or she is under 18, the parents are supposed to keep him safe and keep him away from the crime. So the court is actually now asking them to come and see, okay, your child has committed something, because there are some parents who are ignorant, okay, they do not know what their child's actually doing and so on, okay. So section 88 provides that moral and legal duty. Okay, next we come to section 90. What it says, this is a procedure just like your summary trial, okay, just that you change the accused now to a child, okay. So of course a child, he might be more vulnerable, might be not totally, it's not a confirmation, this one might be more vulnerable and might not understand certain consequences. So the court actually, the CFCC actually place more attention for the child. Okay, first of all, CFC has a duty to explain to the child in simple language. If you talk like us, probably he wouldn't understand. So a more simple language, and this duty may be undertaken by the defense counsel or others. Who is others? Others means it can be the interpreter, it can be the magistrate himself, or it can be the parents. Okay, CFC shall ask whether the child admits to the facts of the offense. Admits, okay. If the child admits the facts, then the CFC will ascertain that he understands the nature and consequences. This one is very important, the nature and consequences of his admission. Here we don't use the word plead, you see. We use the word admit. Okay, admit, admission. Okay, admits the facts, CFC shall ascertain that he understands the nature and consequence of his admission and record a finding of guilt. This is particularly important when you're writing this CFC matter, yeah? Okay, if the child does not admit the facts, CFC shall then hear the evidence of the witness. So you see, it's like pleading. It's like a plea. Once you plead guilty, then we record the finding of guilt. If you don't plead guilty, then we go for trial. Then we call the witnesses, yeah? After the EIC of each witness, the witness may be cross-examined. Totally the same, yeah? So why I say this is particularly simple, just that you need to remember the sections, yeah? CFC shall, except if he's legally represented, allow the parents or guardians or others to assist him in his defense. Okay, this one, he can actually call for a lawyer, definitely. However, if he's not represented, the court may allow parents, guardians, or interpreter, etc., to assist him in his defense. This is quite common, especially when the child is not from a very good background and probably the parents is not in, so they might need another interpreter to assist him. Yeah. So if the child isn't represented or assisted in his defense, the CFC shall assist the child. So this would be the duty of a court, meaning that not represented, no one to actually help the child. Probably he doesn't understand BM, he doesn't understand whatever language. So the CFC shall see what are the ways. Probably he only understand Mandarin or Tamil, so they will get an interpreter of such to assist. Yeah. Okay, as usual, if the prima facie is made out, you see, when we go into defense co-witness, then after that will be the prima facie, right, on the surface. So CFC shall explain to him the evidence against him. He is allowed to give evidence on oath or make any statement. Defendant's witness evidence shall be heard. Same, exactly the same as when the defense is called in the normal courts. Yeah. So if the CFC finds that the child isn't guilty, CFC shall record the order of acquittal. Common sense, we all know this. Okay. If it's guilty, shall ask whether the parent or guardian desires to say anything or to mitigate the penalty. So just think about it this way, lah. If in the courts, in the normal courts, when you are found guilty, your defense counsel will do the job to mitigate for you. But for CFC, the parent or guardian will actually help you to mitigate. Yeah, just remember that. One difference there. Before deciding the order, CFC shall consider probation report and advisor's opinion. You still remember that we have two advisors, right? The magistrate in the center, and we do have two advisors by our side, and one of them must be women. So they should look into their report as well. Yeah. CFC, however, isn't bound to conform to the opinion of the advisors. Yes, they are ought to consider, but not bound to confirm it, meaning that they can not follow the opinions of the advisor. If someone is aggrieved, the aggrieved party, meaning the accused, the child, can actually appeal to the High Court if he is unsatisfied with the outcome or the findings. Yeah? This is as per Section 95. So let's do a bit of recap, shall we? Okay, so we have Section 2 at first. You define what is a child. Subsequently, we have Section 12. Okay, no need to go into the subsections lah. We just go briefly. Different building or sittings, different days, same premise, but different entrance and exit. Okay. Then we have Section 11, just now was 12, 11. 11 will be can try all offenses except those who are which are punishable with death. You can just think of this CFC as a sessions court lah. Everything you can try, but except it. Yeah. So charges 83. Remember these three exceptions. This is just now I mentioned from the date of he or she being charged. Then we have 84. This one same, bail 24 hours as per your 117. 84, this one, yeah, same, magistrate. And lastly, we have this Section 88, which places a duty to their parents, okay, parents of the child to attend. Okay. And Section 90, or more or less the same as I mentioned earlier, except when you say plea, you say what? It's not plea, it's admit, yeah, and admission, okay? Then after the closing of the defense, to mitigate, it's not the legal counsel, okay? It would be the parent or the guardian. Okay? Of course, in practical, the legal counsel will say something, but for exam's sake, just write it down, okay? And the aggrieved party may appeal to the HC, the High Court, Section 95. Okay, lastly, we have covered the last part of it, powers and orders. So Section 91 of the Child Act provides that the CFC have the power to admonish and discharge a child, meaning that you are free to go, you are a free man. Discharge with a bond for good behavior. This one doesn't leave a criminal record, meaning that he or she might have several regulations, and he or she might need to go back to the police station and report himself or herself every week, every month, depending on the court. Okay, order the child to be placed in the care of a relative or other fit person, meaning that probably the family is quite bad, probably quite unfortunate, so they might order this as well. Okay. Order the child to pay a fine, compensation, or costs. Make a probation order under Section 98. Order the child to be sent to an approved school or Henry Gurney school. Okay, 10 strokes of whipping. Okay, how many strokes maximum for whipping? Normally for adult, 24 strokes, but for child, it's only 10. This one keep in mind. For the whip for child, is different from the adult one. It's different. Okay. For adult one, normally, if not mistaken, is half an inch maximum. But for the child, it's actually the smaller type. So 10 strokes or imprisonment if he's 14 years of 14 and above. So normally the court would actually not to go for imprisonment because it's quite detrimental to the child's future. If he or she is not carrying out something very grave, normally they will just do all of this, like good bond behavior and so on, if it's not a grave crime. Okay. Okay. Section 97, this one more to remember. A child cannot be sentenced to death, even though he is charged with 302. Okay. No. He will be detained at the pleasure of Yang di-Pertuan Agong or the ruler or the governor of the state. Okay, this one, remember, this phrase is particularly important as well. So detained at the pleasure of YDPA. Okay, if you cannot remember so long, just YDPA, detained at the pleasure of YDPA. That's all, yeah. So this is for CFC. I guess I'll be covering bail as well, right, Dr. Chee? Okay, let's go to bail. Just a minute. Slides. Okay, for bail, we should start with two first. One is bailable, another is unbailable. Another one is, bailable, non-bailable, unbailable. There are three types. Just remember this. Bailable, 387. Non-bailable, 388. Unbailable, no section. Okay, remember this. This is how I used to study and memorize. So bailable offense, actually nothing much you could, there's nothing much for them to ask. Okay, you can just probably just write a short one. This is a bailable offense under section 387. That's all, okay? But for this 388, this one is where the technicality comes in. You see, in this PP and against Mat Zion, okay, it was held that the general rule is that the court of OCPD has the discretion to grant bail for non-bailable offenses depending on the circumstances and facts. Okay, why there is OCPD, why there's court? Yeah, I have students asking, why court? Actually, this bill is given by court or police. It's actually both. Either of them could actually grant this bail, okay? So what are the circumstances of the police or court granting the bail? The first one you could see, situation one, but this is, you could just write it briefly. You don't need to go into detail for this situation 1, 2, 3, okay? The first and second situation, let's group it together. It'll be there is no reasonable grounds to believe that he is guilty, or there's reasonable grounds to believe that he is guilty. Okay. The third one will be he is under 16 years, meaning that they're sort of a minor, or a woman, or any person who is sick or infirm. Okay, meaning that probably he's having some kind of very bad disease and he's very old, 80 over age. Yeah. As per the case of PP against Dato' Balwan Singh, the landmark case, the first case, I believe, in Malaysia, the accused was charged with section 302. However, he was granted bail. Okay. So for this non-bailable offense, 388, please remember this, the case of Wee Swee Hsien. Okay, 9 factors ought to be considered before granting bail. I can tell you one story about this. During my examination, this question, I think, was 7 marks. And it was actually at when we flipped the page, right, it was at the top of the page, the next page. And I totally missed out this question. I was like day and night memorizing these 9 factors. But during the exam day, I actually missed out this question. The whole question, I left it blank. Okay? Yeah, okay. So there are actually 9 factors. How would you actually memorize? How did I memorize back then? I get the keyword. For example, this one, grounds, right? G. Nature and gravity, I put G again. Severity and degree of punishment, I take the S law. Danger of the accused absconding, I took the D. Okay, so I put it into like a chain of alphabets. So for me, it's easy for me to what we call it, to memorize. So reasonable grounds to believe that the accused is not guilty. nature and gravity of the offense, severity and degree of punishment, danger of the accused absconding and the accused character, danger of being continued or repeated, danger of witnesses being tampered. This one meaning that, for example, he is a drug dealer, this and that, so he might go and tamper the witness if he's out on bail. Opportunity of accused to prepare defense and the length of detention. Because some of the cases I see been dragging for so long, 6 months, 9 months, takkan my client's going to sit there and wait for your wait for your delay. So I might want him out to enjoy his life first. After that, he will go in and face the charges. Okay. So this one, no shortcut. Sorry, no shortcut. I couldn't have a shortcut for you all. Just get the words like I said, then you just memorize everything. 9 factors. What if during exam, you only remember 6? Then you write 9, including, but not limited to, continue your 6 factors. Yeah. Okay, in the case of Dato Sri Anwar Ibrahim, one thing I would like to add, the presumption of innocence is no longer a consideration. So previously, they should consider this innocence until proven guilty. But the case of Dato Sri Anwar Ibrahim held that presumption of innocence is no longer considered. Okay, this one is one thing which you could keep in mind. Yeah. Okay, so we go to this situation number 3. This one actually nothing much to say to be honest. So you just remember there was a case in Lechemi. This female mother was actually on breastfeeding, but the bill was rejected by the court. So not necessarily that you are infirm or maybe you're a woman, then they will actually grant bail. Okay. However, in the case of this Jesu binti Daud, bail was granted because A was a mother of 6. Accused was a mother of 6 and was breastfeeding. So I get a lot of questions. So what is the right answer they have been asking? I can tell you there's no right or wrong answer. Yeah. As lawyers, you have to dispute and dispute and dispute. Don't seek for the right answer. Okay. Seek for what is right for you. Okay. And the justice. So there's no right or wrong answer. You can put as CF, contrasting factor. Okay. So at the end of the question, it's not necessarily that you have to deliver a conclusion which is like precise. No such thing. Okay. You can dispute however you want. Because keep in mind that the examiners are actually legal practitioners, judges, and so on. So you should actually put something like a contrasting factor and so on. Okay, unbailable offense. This one is pretty easy, meaning that, for example, under this FIPA, Firearms Increased Penalty Act 1971, or the 41B of DDA. Okay, these are the major offenses, including the drug cases and so on. So this one is totally unbailable. For example, the clients of 39B, they have to sit in the detention center. It's also like a jail. They have to sit until the trial ends. Okay, so there's no way out. Okay, let's go to this pending appeal. Okay, this one is bail pending appeal. In short, there are 2 headings. One is against conviction by accused. Another one would be against acquittal by prosecution. So what are the differences actually? This one is actually you are appealing as an accused against your conviction. Probably you were convicted at the High Court. Okay, then you wanted to appeal. Okay, so probably you are sentenced to 5 years of imprisonment. Okay, you are not satisfied with it. Now you want to appeal. So you want to stay the execution first, right? So you ought to apply for this bail as well, because you want to come out, you want to enjoy your life. Okay. So this one is as per section 311. You can have a look. And Another case, this one just now was what? We Sui Xiang, 9 factors, right? Now you have another 6. This one, I betul-betul, I hafal everything, but sadly, this one didn't come out in my examination. And the one came out, I didn't do. Okay, this one is Ri Huan Hua Yip. Okay, the case. This one, you have to memorize, no shortcut as well. How did I memorize back then? Also, I get the alphabets and make into a chain for me to memorize. So the gravity of the offense, the length of term of imprisonment, and time for the appeal to be heard. For example, the appeal is 1 year or maybe 6 months down the road. My client couldn't be sitting in the prison just to wait these 6 months. What if he is innocent, right? So there are some kind of this consideration. So this court will consider as well, and whether difficult point of laws are involved, because when you appeal, normally it's on a point of law. For example, from HC to DCOA, yeah, it's always on a point of law, right? Whether the accused is a first offender, it's not like rampant, like, in and out the jail, like their own home. It's like first offender, they will consider possibility of accused being involved again in similar offenses. So this one, they will consider as well. And whether the security imposed will ensure the attendance of the accused. Meaning that, for example, is there a risk of him absconding? This one is one question they will ask. Probably they will set a bill, 10,000, 20,000. Probably the accused will still escape. So they will consider this. Yeah, here, Dato Sri Abah Ibrahim, presumption of innocence is no longer a factor to consider. Yeah, so this one I've mentioned earlier. This one against acquittal by PP. So this one will actually be raised by the PP normally. Okay, courts may order bail pending appeal against acquittal under section 315. This one. Okay. Meaning what, this one? This one is actually when the accused is acquitted. For example, in Sessions Court, you were granted a DAA. So now the prosecution is actually appealing to the High Court, am I right? So just now was convicted, now is acquitted. Okay. So you quote the case of man against PP and also section 315. Okay. So this one, you should actually kind of remember as well. You don't have to really go and memorize for this one. So section 315 shows that the intention of the legislature that grant bail is the rule and committed to prison without bail is an exception. Meaning that normally, right, the court will actually grant bail. Because you have been sentenced, you have been acquitted, you have been acquitted. So what is the point for you to go back to prison again, right? Okay, so this is the actual rationale, yeah? So discretion in favor of PP is exercised sparingly if there are special circumstances. Okay, what this means is actually this. For example, you are a drug lord. Fictitious, this one I'm not referring to anyone. You are a drug lord and you stay very close to Thailand, for example. So there is a risk of you absconding by a sampan or a boat. Okay. So will the court actually grant bail in this case? Normally, they are very reluctant to grant. Okay. So this is what this means. Discretion in favor of PP is exercised sparingly under special circumstances. Okay, next, we do have this quantum of bail should be realistic. This one, you can touch a bit, meaning that you should say that probably the question will be, okay, the quantum of bail will be 10 million or maybe 5 million. So this is absolutely not realistic. Yeah. So you could argue this must be realistic. The next would be, it is desirable to order an early hearing of appeal. Okay, this one self-explanatory. Okay. Let's come to the next one. Okay, appeal against bail decision. This is particularly important and students get confused between these two. 394 and 389. So for 394, aggrieved person, you see, may appeal to the High Court by notice of appeal after the court's ground of decision is ready and file the petition of appeal. Do you know how long this would take? Very long. Okay, so we have a faster one. Any person may appeal against the decision by way of motion. The High Court may grant, reduce, or increase bail. Why are there two differences? Okay, I can tell you, very simple. For 389, there is no way for the High Court to revoke the bail. But for 394, the High Court can actually revoke the bail. So, in simple terms, if you are the accused, you use 389. But if you are the PP, you don't want the accused to be bailed out, you use 394 because it allows the High Court to actually revoke the bail. So this is the difference between. Okay, keep in mind. Okay, this one, bail law, forfeiture of bond. Actually, nothing much lah. I don't want to spend too much time on this. Okay, so meaning that it's very simple. It's a penjamin thing lah. Okay, you are granted a bail. Of course, you need a surety, right? Okay, so get used to get familiar to the terms bail law, surety, bond. Okay, bail law is a person, the accused. For example, I was arrested under bail law. So Dr. Chee came to my rescue. He agreed to become my surety. Okay, he's the penjamin, you know. So anything, if I don't appear, they will fine him. Yeah. And bond. Oh, my money has been confiscated, each and every cent. So Dr. Chee is a kind person. So he took out 1 million ringgit to actually bail me out. Yeah. So bail law, surety, and bond. Okay. So you see, when an accused is released by bail or on bail by the surety, Dr. Chee come and jamin saya lah, okay? Who must ensure the accused attends at the place and or the time required? Dr. Chee will have a duty, okay? He will need to inform that, hey, Gan, okay, next Tuesday, you must go. He should actually do such a thing to remind me, okay? However, if you see, next Tuesday also I say, I don't want to go, I'm lazy. So Dr. Chee can actually apply to the magistrate to discharge the bond, meaning that he doesn't want to become a penjamin anymore. Okay. So in simple words, once you have discharged yourself as surety, then I'll be arrested because the bond is actually cancelled, right? The bail is actually cancelled, sorry. Yeah. So the forfeiture of bond, you see, if the term or condition of such a bond is breached, okay, then the court may forfeit such a bond, meaning that the 1 million ringgit, if I fail to attend, Dr. Chee's 1 million ringgit will burn in short. Okay. Then see, Section 404 provides that whenever a bond for appearance is taken and such bond is forfeited, the court shall record the grounds of such proof and may call the sureties to show cause. Meaning that, okay, now I didn't appear right next Tuesday. So the court would actually record the grounds, okay, and call Dr. Chee. Dr. Chee, can you come on Friday? I want you to show cause. So Dr. Chee will go there. He will show the court 100 WhatsApp messages, but not even one did I reply. This is actually sufficient proof and grounds. And he even visited me, but there was no one in the house, meaning that he had taken all the reasonable care to ensure my attendance, but still he is unable to secure my attendance. If sufficient cause isn't shown and the penalty isn't paid, the court may issue a warrant for the attachment and sale of property. Okay, let's talk about if sufficient cause has been shown, meaning that Dr. Chee's 1 million will probably be gotten back. Okay, this is one thing. If it isn't shown, meaning that, okay, Dr. Chee actually did nothing, did nothing to secure my attendance, then what happened? May issue a warrant for the attachment and sale of the property, meaning that Dr. Chee's BMW, everything will be sold off. See? So this is what happens. Okay. Okay. If such penalty isn't paid, sureties will be liable to imprisonment in a civil prison up to 6 months. Yeah. So this is another of the This one?
Go ahead. I have a question.
Yes.
Yeah, regards to the forfeiture of the bond sum, right? So, meaning that they'll be forfeiting the bond and also will be imposing an additional penalty, is it? To make things clear?
Yes. Correct. You see,
Okay, sure. Thank you.
yeah, the process is this. Meaning that once just a minute, my Zoom is a bit lagging. Yeah. So meaning that if you are able to show cause, okay, Dr. Chee is able to show cause, no issue. If he fail to show cause, then these are the consequences lah. Okay. So these are some of the cases you could go, which is say Dato Haji Harun going overseas isn't sufficient cost. So let's see what is sufficient cost. See, in Ramli, in the case of Ramli, surety, which is Dr. Chee, had sufficient cost. He had taken various steps to ensure that the attendance of me. So see, he had actually texted me, he came to my house, etc. So I think I actually that's all. I pass over to Dr. Chee, then later on I'll continue. Yeah. Yeah, bro, you might share your slide.
Okay. Wait, just you want me to cover the charges part, is it?
Yeah.
Okay. So charges is just you try to be a little bit imaginative. Charge is something to because when you being charged, I mean when the PP or DPP try to bring accused to the court, the first thing will be done would be reading of charge to the OKT, the accused first. So the purpose of the charge is to let him understand which section of penal code or whatsoever criminal laws that he or she had offended, and also the sentences that is going to be imposed on this particular person. Okay, so you must just understand this way, and the charge is just a piece of charge sheet, going to be given by the DPP to the court as well as to the defense counsel. And the format to draft the charge will be stated in your section 152 onwards. Okay, to make it very simple, you do not just memorize, how to say, just to memorize all the section. You must try to appreciate the law by its operation, to put in your imagination. So what a charge should contain? To me, it is just like a statement of claim, in civil law. Very simple. Just think of that. If PP wanted to show to the court that an accused had committed certain type of offense, and the charges will be containing all the information pertaining to the offense. First, it will contain the law as well as the punishment, which section, okay? Which section? For example, section 302 for murder. You have your section 39B, drug trafficking. Okay, this is the one of the compulsory requirement. And subsequently, you need to tell the court the time, date, and place. Okay, so and so, you, usually they'll start that way, that you had on, had been found in Jalan Kulang, number 3, Jalan Kulang, this 8600, the address, okay, at about now is what time? 9:30. Okay, you have been found to have possession with 1 packet of heroin inside your pocket, and also found in my bedrooms whatsoever. So the detail of this information must be contained in the charge itself. Sometimes you need to state the manner of committing, but this is not compulsory. It depends on on the offense committed. For example, the murder is not required, but cheating, how you cheat is required. Okay, I cheat Mr. Example. So this manner you have to state in certain types of offenses. Okay. So in drafting the charge, I think this one is not so hard, you know. They will ask you a little bit errors with the charge, but you must understand that this is just a technicality issue. It's just a form, and it's always there's a chance prosecution to So whenever you have I think Mr. Gunn had well covered the amendment of charge. Amendment of charge can be done so long it is being read and explained to the accused. But there are some case laws that even though it is not read to the accused can still be convicted with the amended charge. The gist of the problems here is whether it causes substantial miscarriage of justice or it carries serious prejudice to the accused. So long it is not, then the court will allow the amendment. Otherwise, what is going to happen? If the whole charge is deemed to be illegal, the court will order a retrial, you know. It's still the same because charge is being read at the very beginning of the stage of either your summary trial or your high court trial. So actually just go back to square one only. They amend, they still charge you. It doesn't mean that the charge is faulty, the charge is not valid, illegal, then just remember that. So usually the charge issue is hardly challenged. Okay, I would say it's hardly challenged unless, like I said, it causes serious prejudice or even miscarriage of justice. Okay, I think the second part here is very important. Can you all still see, right? I mean, my slides here can see. This is the exception of when we draft charge. Okay, you must remember section 163. Forget about the limb. Just be imaginative. Okay, in the sense that, okay, every single charge, okay, take for example, after the class, suddenly a group of narcotics police raid my room, the room that I rented. Not my house also. This is my sister's house I'm staying. Okay, the house does not belong to me. But now they found packets of heroin, one inside my pocket. Second one is behind the television. Okay. And the third packet is under the bed. Okay, and I was found to be in control and also in possession of drugs. So how many charges I'm going to face? Any good guess? 3 packet of what we call 3 packet of drugs. Okay, I'll answer myself lah, easier. 3 charges. Section 39B. If the drug is such a big packet lah, okay, more than personal consumption. So that means to say the charge, even though the drugs was found in one room, but in separate places, you know. So actually they can frame 3 charges against me. That means 3 charges they cannot write one charge, combine 3 offenses like, okay, that you on 21st June 2023 at or about 9:30 p.m. had been found drugs, heroin, I mean, a gross weight about 1 kg, behind the television, under the bed, ecstasy, 10,000 pills, and also inside my pocket, probably there's only 5 pills of amphetamine. Okay, something like that. So they have to draft 3 charge sheets towards those distinct offenses. Okay, that is the one that you must remember. And those once you have these different charges, by right, I am subjected to 3 separate charges, you know. You get what I mean? One section 39B for the heroin, okay, one for the amphetamine, and one for the ecstasy form. So every single trial I have to go through the prosecution case, and then the witness prosecution need to call, even though the same people, same batch of people, but I have to repeat this trial for 3 times. And every single trial, there will be a different sentences and also judgment. Okay, get it? So this is the general rules, you know. But there are some exceptions. I think the exception part is very important. And I think somebody asked about the duplicity of charge. Okay, duplicity of charge, that means one charge sheet content of more than 2 offenses. By right, one charge sheet, 1 offense. Okay, so the test is being set down in the case of CU Paul here. Okay, whether to held the duplicity of the charge itself is an illegality or an irregularity. The test is like this: if the charge contains 2 separate offenses, which could have proceeded on 2 separate charges at 1 trial. Like I say, by right, I should have 3 trials. Now they combine everything in 1 charge sheet. Okay. If let's say the trial memang cannot just be done in 1 trial, then the whole thing is actually could not be cured. You get what I mean? Okay. If it can be what we call, if it is can be done in 1 trial, okay, that means to say, even though I have combined everything and only 1 trial is needed, then it can be cured. Okay, very simple. Okay, and I think you need to pay particular attention. I think this is a favorite examination question, you know. You need to pay particular exception to section 153 sub rule 2, whereby some charges can be jointly just put in 1 single charge sheet. This is particularly with criminal breach of trust. I think this is part of the policy reason. Otherwise, this guy, I mean, let's say I'm partner of a law firm. Okay, I have been I have been abusing my power to take money from the clients or make some false claims from my law firm. Therefore, I committed criminal breach of trust. But I have been very persistent, you know. 1 week I did 1 time. So I have been doing so many 52 weeks. Every week I did. So 1 year I committed 52 times of CBT from my law firm. Okay. So Chris and partner is very pitiful in this sense. So there's no logical sense, you know, because corruption itself, all that is quite rampant. There's not logical that I have to, I mean, it's a waste of resources and also the court money, court time, okay, as well as the prosecutions, calling witness, all that, so much of hassles. Okay, so sometimes these sort of crimes can be combined together or joined together. Okay, remember your section 153 sub rule 2. Okay, and you must also be well versed with section 164, 165, 166. Okay, 166, 164, 165, 166, there is 1 accused only. Okay, 1 accused only. Okay, there are no other party. So whether it can be joint trial or not, okay, to facilitate, because evidence, all that will be almost the same. So what are the exceptions? Okay, the exception will be Section 164, if 3 offenses committed at the same of the same kind committed within 12 months. Okay, take for example, I committed theft from 7-Eleven in the morning today, as well as next month, I steal again mineral water. Okay, and probably in upcoming August, I am getting thirsty. Okay, I steal again. Okay, not finished yet. So September, I steal again. So 4 times I steal. So to facilitate the court, actually I will be only subjected to 2 tribes. 2 tribes, okay? The first tranche will be the stealing of today punya mineral water, next month punya mineral water, as well as the August punya mineral water. And the second trial will be separate because it's more than 3 already. So September one will be another separate trial. Even though the shopkeeper is the same, the CCTV tender will be the same, okay, the witness will be the same, CCTV tender a little bit different, but showing that I steal with the same manner. So you get me. So this one very important, okay. And what are other situations that joint trial or can be I mean held at one time? Okay, if the crime is committed in during the same transaction, you know, because you must realize sometimes there could be an aggravated crimes. Okay, my purpose to go to 7-Eleven by right is to steal mineral water. Okay, but subsequently, during the commission of the crime, I get noticed by shopkeeper who is Mr. Gunn. Mr. Gunn is shopkeeper that time. So he detected me, he shouted. So I got provoked. Okay, I got provocation. And then I stabbed him with a knife. So it becomes theft plus voluntarily causing grievous harm to Mr. Gunn. So this one, actually, if it is committed at the same place, same time, and also is a continuity, actually, I wanted to steal, but I also committed aggravated crime. The violent towards Mr. Gunn, then it can be combined under Section 165. Okay, as simple as that. Okay. So Section 166 is for doubtful offenses. Okay, when the thing is very doubtful. Okay, back to the example that I am the partner of the law firm. I love to steal. My nature is I memang love to steal lah. Okay, so the law firm lost a printer. Okay, a HP printer, and it was found in my house. You know, it was found in my house, and I got caught. Okay, so because I'm a lawyer, so what I did is during the interrogation, I kept myself silent. I don't want to be cooperative with the police, but the stolen property was found in my house, correct? So either I could be charged with theft or receiving stolen good. Reason being because I refuse to give any further information. So we don't know if my colleague, the gun was the one that sold the HP printer to me. So I'm just actually receiving stolen, what we call stolen printer, you know. So we do not know. Okay. Or either I commit criminal breach of trust. So usually these sort of doubtful things you can actually help in same trial. Okay, you can join together. Okay, and Section 170 provided where a joint trial, okay, can be held is 2 or more accused. So whenever you see question consists of 2 or 3 or even 4 accused, then you must start thinking of Section 170 only, Section 170, committed the same offense. This is, for example, okay, we take the case of Sosilawati, TP against Padmanabhan Narayanan here. Okay, there are 4 people. The main mastermind is Mr. Padmanabhan, and he was a lawyer actually. He killed the Sosilawati, who is the cosmetic businesswoman, Batin, and kill also the what we call the PA as well as the lawyer. Okay, and then they burn the car in a ladang. Okay, they are actually 4 accused work together in this scenario. So provided it is done within the same transaction, I mean on the same day, on the same place, okay, and also with the same uniformity of the design. Memang the purpose is to kill Sosilawati as well as the her companions, then you can use section 170 to charge. Okay, that's why you see the case law is PP against Pamanaban and others. Okay, actually there are another 3 accused together. Okay, so this is how the operation of section 170 subrule 1. Okay, and section 170 subrule 2 provides when there are 3 categories of offenses which may be charged and tried jointly. This is usually in regards to our policy, because theft, extortion, CBT, cheating, all that is very rampant among the society of Malaysia. So it is really a waste of resource, because delay justice is no justice. So you must always remember, to save time, to save everybody costing, better charge them under one shot, one trial, finish the whole thing and get them convicted. So this is how it works. So I repeat myself, if there's only one accused, the relevant section that you should refer, section 164, 165, as well as 166. There are some illustrations provided in your CPC. You may have a thorough read for yourself. If there's more than 2 accused, the proper section that you should refer will be section 170. Okay?
Hello. Hi.
Yeah.
I want to ask one thing. For the normally the question is asking about whether joinder of offenses or charges, right? So we normally write 163 and then dismiss whether the exception, we dismiss every exception, right?
Correct.
So first, I want to ask first, we need to write duplicity first, then only we go to the exception. I mean, 165, 167, 170, or we can straight away go to the 164.
No, you cannot go like that. You must state out the general principle under section 163.
Yeah,
Okay.
then only we have to write duplicity, right?
The duplicity simply means one charge sheet itself contains several offenses, So you must distinguish, okay, section 163 has got who, You don't confuse with the wording. My style, I learned my law by trying to be in the position as I'm the PP that draft the charge sheet. Okay, section 163 by right, one charge, one offense, one charge sheet. For example, I give you the heroin, amphetamine, and also the ecstasy thing. By right, I should have 3 charges, charge sheet, I have to draft 3 charge sheet. The duplicity means they combine everything, they join together in one charge sheet. You get me?
Okay. So okay, so in that question, so if they combine every offenses, then only we have to write duplicity, right?
Okay, you just have to state the general rule. You do not need to get yourself into uncertainty. Okay, first thing, you read the question. Okay. You must first, my approach, you identify how many accusers first. If there's only one, usually, okay, they will ask about the duplicity of the charges if it is being committed in one day. You agree with me?
Yeah.
You get me? So after that, you write the general rule: one offense, one charge, and one charge, one trial.
Yeah.
You get me? One offense, one charge sheet, one trial.
Yeah.
This is all the general rule. Then subsequently, you have to evaluate section. If there's one accused I'm talking about, then you evaluate whether section 164, 165, and 166 fit into your given scenario or not. Usually no lah.
Yeah.
Usually no. Then you
Usually I
dismiss
dismiss.
them lah. Yeah, you have to dismiss confidently. Seriously, you have to dismiss confidently.
Yeah,
But you
yeah.
have to write, But when there's only one accused, don't write section 170, There's a
Okay.
lot of people make mistake because one accused, why you want to write 170?
Oh, so we no need to write that it is not applicable because there is only one accused.
And you
We
can
are not-
write that way. You can
Ah.
write that way. You can write that way. No problem.
Okay,
Huh.
okay. Thank you, thank you.
Can okay. So okay, we continue with where were we? Okay, conviction for offenses not charged. Okay. For example, if just now we just mentioned that the charge is just a paper, it's a technical formality to inform the accused about what is the law he infringed and the sentences that is going to be imposed to him. Okay, so that the defense counsel also get aware, then he can prepare the defense strategies. So there are actually some events, but like I say, this thing is just a formality. It depends on the whole trial process, whatever the witnesses and also the evidence and the defense tender. Okay, how the defense work. General rule, if it does not prejudice the accused, even though let's say I was charged with I was charged with rape lah. Eventually, the sentences imposed, the judgment given by the court can be aggravated rape as well, So we'll see from section 167 to 169. So what are the scenario? Okay. So this one, you just have a general idea first. Then you go into the details. Okay. So section 167, usually we read with section 166. Section 166 means when the offense is doubtful. Just like the scenario I have given to you, I'm the partner of the firm. There was a stolen printer found in my house. So whether I committed CBT, theft, or receiving stolen good, we don't know. Okay, so the charge is framed with different offense. Okay, but eventually I can be only convicted with theft. Okay, it was shown that subsequently, whatever the evidence that I've submitted, the PP has submitted, as well as the defense has submitted, okay, show that it was theft. Okay, but the whole facts and also the evidence must be the same with the theft issue. Okay, you get me? This is how it works. Okay. Not too difficult. Don't get confused with the wording. Try to understand with your own words. I think it will be, how to say, you memorize it for quite long, okay? Because section, you read every single sentence, it sort of cracked my head, I don't know how about you. It cracked my head. So I normally digest with my own example. I see how the law works, okay? It helps. So section 168 said what? The accused may be convicted of having attempted to commit the offense, though the attempt is not separately charged. Okay, so that means to say, he was tried for murder. Okay, take for example, Mr. Gan and me, suddenly we involved with the murder. I have to use my master because this is the safest person that we can kill. So we sort of involved, but eventually probably we have contributed Okay, probably I strangulate my master, and Mr. Gan will have a stab my master. So the cause of death very difficult to what we call to determine who is the actual murderer. Okay, so sometimes in this sort of case, instead of section 302 murder, eventually the judgment can be on attempting murder. It could happen also. Okay, and section 169 subrule 1 say what? Some of the particular are proven which constitute a minor offense. Okay, the minor offense, you must be aware of this case of Liu Chok Hin. Okay, the minor offense here, I would like to bring your attention to one section. Okay, since we talk about rape just now, I think I need to bring your attention to section 376. If you open here, 376. Okay. If you look at 376 subrule 2, aggravated rape, okay, which carries the imprisonment for not less than 10 years and not less than 30 years and whipping. Okay, I could be charged initially with aggravated rape, means that I raped a woman as well as I have used some violence during the rape process. Probably I will have beaten her as well, okay, during the criminal process. But I could be only charged with rape. Okay, the minor offense here means the aggravated wording in section 376 subrule 2 was deleted from the charge. It becomes a minor charge, you know. That means to say the imprisonment will be for 20 years and whipping, okay? At least I can put in my mitigation factors, probably I'll get 5-6 years imprisonment, okay? Rather than the aggravated rape, which carries not less than 10 years, you know. So this is what it means by minor offense under the proviso of section 169 sub rule 1, okay? So I think section 162 sub rule 2 also is similar if the facts proof which reduce to a minor offense. Like I said, they charge me for aggravated rape, okay, because they saw some bruisings, you know, some bodily injuries on the victim, but subsequently they could not prove I'm the one that hit her because no CCTV. They only found the evidence of penetration. Probably my semen is there, DNA evidence, and also there's no consent element, non-consensual. They could only establish this, okay, not the beating. So they can put into a minor offense of rape. So, how to say, please understand this with your heart, okay? So whenever an accused with multiple charges, take for example, I was charged with 3 counts of section 39B. Okay, I have 3 charge sheets and 3 different trials ongoing. So one trial already finished, and then I was convicted. You see, I was convicted, and the other 2 trials are still pending and running because sometimes chemist report, and then the what we call the witness could not be present all the time because 3 separate trials, correct? One I already get convicted, okay. And I was given sentences already. So usually what the defense counsel will see the section 39, of course now we do not have death penalty, but usually it's life imprisonment already. So usually my defense counsel will just go and talk to the PP and with the consent of the court just approach PP. Why not you drop the other section 39B okay, you drop it since you already got convicted. Actually, it can be done under section 171 CPC. Okay, so usually this is based on humanitarian reason, okay, because one already get convicted and then subsequently DPP or PP can actually withdraw. Okay, so section 171A is also similar if there are some outstanding offenses when sentencing. That means to say, okay, I was found guilty on an offense. For example, the 7-Eleven example, I went to the 7-Eleven, I steal a mineral water, theft, correct? I was convicted with the theft because CCTV evidence was there. I memang took it away. And also the outstanding offenses because it is joined together. And just imagine, what about the stabbing of Mr. Gan as shopkeeper? The one causing grievous bodily harm. So actually with the consent of PP and also the accused, the court can ambil kira, to make one sentence, okay? But sometimes negotiation need to be taken place. Otherwise, the whole sentence may be a shock to the accused, because eventually they combine everything, it becomes how to say, it becomes a very severe punishment to the accused. But then the court can do so as well as the PP with the provided both party agree. Okay, accused must agree, as well as the PP must also agree on that. Okay, so this is how this law works lah. Yeah, bro, I think your turn, isn't it? The sentencing part.
Okay, thank you so much, bro, for the detailed explanation.
Yeah.
Thank you so much. Thank you so much. So I'll share my slides. So today will be OT a bit, because it's really a lot to cover, you see. So we're having some OT. Hope you guys bear with us. And at the end of the session, we have some question and answer lah. Okay. Because I believe you guys won't sleep early, right? I think 25 days with 2-3 o'clock. Okay, so now we go to types of sentencing. Okay, of course there are death sentences still for 302, 364, 39B. A lot of them saying that, now death penalty has been abolished for 39B. Actually not. You need to fulfill certain criteria. In short, you need to fulfill the fact that you have actually assisted a law enforcement agency in what we call that, in actually busting drugs and you need a law enforcement agent to actually testify in court in order for you to get that reduction. It's called Budi Bicara Mahkamah lah. Okay, so that's just for additional info. Subsequently, okay, what are the exceptions? Who can't be sentenced to death? It'll be a pregnant woman and also a child under the Child's Act. So what happened to a child when he's sort of sentenced to death? He will not be sentenced to death, but detained at the pleasure of YDPA, as we mentioned earlier. Okay. So Section 281 provides that the procedure in the execution of a death sentence. So this one normally won't be asked in your examination. Normally, disclaimer. So okay. For imprisonment wise, here there is actually one error. I'd like you to take note, just a slight error here. Okay, this is actually CJA 1963, Criminal Justice Act. This is not CJA 1964. It's not Court of the Adjudicature Act. It's actually Criminal Justice Act. And life imprisonment for life means it's not 20, actually it's 30 years with a remission of wanted for good behavior. Okay, so this one you might take note. There's some slight error. So offenses under the FIPA, Arms Act, and also Section 130 of Penal Code, imprisonment for life means natural life. So normally it will be 30 years. And if your behavior is actually good, you can actually come out slightly earlier. Or you probably get a parole from the ruler or pardon from the ruler, then you can come out as well. Okay, so commencement of the sentence. It shall take effect from the date of on which the sentence was passed. This one is pretty common sense because as per the Section 282 sub D. Okay, if the accused is an escaped convict or is currently serving a sentence, the second sentence may run concurrently or consecutively. Concurrently meaning that, for example, now I have 10 years imprisonment, I have another offense convicted me for another 10 years. Concurrently meaning that I only have to stay in the prison for 10 years. But consecutively would be 10 plus 10. So meaning that I have to stay in for 20 years. Okay, so this is the meaning of concurrently and consecutively. Okay, so okay, this one I would like to straight away jump into this principle, which is the one transaction principle and also the totality principle. Yeah. Sorry, I forgot to put the full screen. Okay, so what does one transaction mean? So these principles, you might use them in your examination while answering sentencing questions. For the one transaction principle, meaning that the charges arise out of the same transaction, meaning that, for example, I stabbed and I robbed. Okay, so two charges in one same transaction while I was robbing one shop. Okay, these normally the sentences are to be run concurrently. So it is called the one transaction principle. Okay. Whereas for the totality principle, so this one is normally for courts to interfere. Okay, meaning that they find that the punishment is too heavy, is too severe. For example, okay, probably 5 + 5. So there are two what we call it, two offenses being committed. The person is sentenced to 5 + 5. Okay, and probably the appeal, the court find that it is too heavy, 10 years. So they may use this totality principle and reduce it probably to 7, or maybe to run concurrently. So the person, maybe they'll be in for 7, or maybe they'll in for 5 only. Okay. Okay, this one, nothing much. So the principles you guys have to keep in mind, because it may come out in the examination. Okay. Okay, so just now I saw some questions regarding whipping. Section 288 of the CPC provides that the number of strokes shall be 24. So the maximum is 24. So in your examination, it might be coming out, probably the guy get 36. I can tell you, if you have 5 strokes or 6 strokes, then you are basically done. If you have seen whipping before. And yeah, it's done. You're done. Only you'll pass out of vessel vagal. And for youthful offenders, as Dr. Chee had mentioned earlier also, the maximum will be 10 strokes. But it's not like those adults lah. It's like just like school caning. Yeah, Dr. Chee used a very right word. It's like a school caning, unlike the adult offender. So section 290, this one is under whipping, yeah. So 290 provides that there shall be a medical officer present and certifies that he is in the fit state of health. Okay, we don't want like when we whip someone and he dies of myocardial infarction or something lah. So not good. So they should actually examine him lah. Okay. However, in certain circumstances, whipping isn't allowed. Okay, where the accused is actually a female. So female actually do have an advantage of getting rid from this whipping. And male sentenced to death. The rationale would be he is already going to die. So what is the purpose of you whipping him again? And a male who attains 50 years of age. So people who actually had attained 50 years of age is actually exempted from whipping. However, there are exceptions, 376 and so on. So these are the offenses related to rape. Okay, so for rape, it is not excluded. You still get whipped. Yeah. 311 CPC and this 57.3 of CJA provides that the sentence of whipping shall be stayed pending appeal. What if now you get 10? In high court, you get probably 1. So who is going to bear that 9? So that is the rationale. It will be stayed, yeah, until the final appeal is out. Okay. Okay, let's look at some case laws. In this Tuan Mat bin Tuan Lonik, so if you can't remember such a long name, just write Tuan Mat lah. It was held that the maximum of whipping is 24 strokes. So looking back at this 288, you have also 24 strokes. So you can just quote 2 in it, and also the case of Tuan Mat. Okay, normally this one, Ho Kin Luan, the whipping is imposed where the evidence of violence and brutality. However, this one is optional, okay? And okay, for whipping, 289 here. Very good. I saw Dr. Chee reminded in the chat box as well. There is no installment. For example, you get 10 strokes, okay? So at the 8th stroke, then you fell, you collapse already. You won't fall, actually, you will actually tie to one, what we call that, one framework. So you won't fall. So you pass out at the 8th stroke. The remaining 2 stroke, you're lucky. You won't get whipped again. Yeah. So you get 8 lah. So 289, no installment. Okay, so this one fine. Believe nothing lah. I mean, nothing much to ask, this fine. However, look at this one, section 283. If there is no sum to be specified for the fine must not be excessive but reasonable. The court may direct the method of payment, and the court may direct imprisonment in default of payment of fine. Okay, so this one, you can flip to your section 283 of CPC, so you can refer from that. What is the duration of imprisonment? So in lieu of this payment of fine, you can have a look at that. Okay. Actually, fine-wise, to be honest, nothing much to ask. I would like to jump to this police supervision, okay? Okay. So police supervision meaning that you have been convicted, okay? So you serve the imprisonment, and the court still thinks that you need police supervision. Okay, as per 295, the police supervision may be imposed if you were previously convicted and presently convicted. Normally, is more than 2 years. Okay, the terms of police supervision, High Court or Sessions Court may direct 3 years, Magistrates Court may direct 1 year. So this is like the maximum ceiling that they can place. So, okay, 295(1)(a) provides that if the accused is convicted under 376, 377, etc., so these are all rape offenses. The supervision must be imposed not less than 1 year and not more than 3 years. Okay. Okay, the obligations. What happens when there is a police supervision? So he must notify his place of residence and report to the police as directed once each month. To be honest, it can be more than that, depending on the court. Okay. If he didn't comply with 296, so it's basically like a committal proceedings, he shall be liable to imprisonment for 1 year. Okay, so when we come to this good behavior bond or binding over, so this is something which most of the people, they never pay attention to. This bond, good behavior bond, actually, it doesn't leave you a criminal record. You see, you will have, in practical, you will have a record at the Valai. The police will have a record of you having this bond, but in the system itself, you are not a convict, you see. So as per this 173A, you can see it is for all offenders. There is no conviction recorded, as I've said. Period of bond cannot exceed 3 years. Usually invoked if the accused is a government servant. Okay, usually. However, for the 294, all offenders, conviction will be recorded. There's no limit to the bond, meaning that unlike this is 3 years. So only applicable to the first offender, condition of bond, you can refer to 294A of the CPC. So why do we need this good behavior bond? Because it's in lieu of this imprisonment time. So you get this good behavior bond instead of getting into the prison. Okay. Community service, this one, normally you just need to know is 293, okay, and discharge. discharge provides that the court be conditional on unconditional discharge on a bond. So it's similarly to this 173A is mentioned. Okay. So basically, just to recap here, we have covered this sentence, imprisonment under Section 3, Criminal Justice Act 1963. The life imprisonment means 30 years with a remission of 1/3. Next, we have whipping, okay? And you do need to know what is the maximum stroke and for youth offender and who is prohibited from getting whipped. Okay, I think this one, Dr. Chee will cover, right, for the sentencing of this second page.
Oh, no, bro. This one, I think you have to. No, me. Let me see.
Okay, never mind.
I think can. I also can. Can.
Never mind, I think I
Why
can.
not?
I can still carry on lah. No problem. Yeah.
Oh, okay, can.
Yeah. Okay. So for the mitigating factor, okay, this one is actually quite common sense and simple. Mitigating factors meaning that how are you going to mitigate and to lower down the sentence. Aggravating factors is normally put forward by the public prosecutor to how are you going to raise or maybe have a heavier sentence, okay? So mitigating factors, it includes what? Age, okay, whether the accused is actually old, okay, or too young, okay. As we have mentioned in the courts for children, for example, the accused is too young, so when they mitigate, they can ask their parents to mitigate as well. Okay, see, in this Tukiran bin Taib, youthful offender shouldn't be in prison, but should be sent to the Henry Gurney School so they could have more opportunity to learn, etc. Okay, the next we have these effects of conviction on family, on job, etc. So this one is basically like when they are going to sentence, then you put forward in short, you say that you are very pity, then hoping that they will actually give a lesser sentence. Effects of conviction on family, okay, maybe he's the sole person working in the family. And next, whether the accused is a first offender. This is a quite a good mitigating factor, meaning that he has only he had actually offended the law only once. So please give him a lighter sentence, another chance. Okay. The next will be conduct. Okay. The accused is ready with for cooperation with the police and so on. So he was all the way quite he obeys basically he obeys to the police, attends the police station for 112, etc. So this can also be a mitigating factor. Okay, the next one will be the guilty plea. As I mentioned earlier, the case of Christopher Koo. So once someone is pleaded guilty, normally, no guarantee, but normally 1/3 of the prison term is reduced. Because why? Because you have saved the court's time. Yeah. Okay. The next one would be the gap period. Okay. So the court would consider between the gap period, meaning that probably the last one would be 20 years back, and now he started committing crimes again. Okay, so the gap is also one of the consideration for mitigating factors lah. And the next one would be condition. For example, he's under provocation, he's having financial problems, he has been instigated by others, yeah, and he might be drunk as well, yeah. So for consent part, normally the counsels will raise it for the offense of rape, yeah, rape. Okay, so let's do a recap. Age, effects of conviction, it's a first offender, guilty plea, conduct, gap period, and condition. So this one actually quite common sense lah. You can just write it out in your examination. Okay, when it comes to aggravating factors, this is put forward by the PP, public prosecutor. The first one would be the prevalence and rampancy. meaning that, for example, CBT, MACCA related offenses. So these are very rampant nowadays, okay, white collar crimes especially. Okay. So the PP will usually press for a heavier sentence. Use of force. Okay, this one actually the police and the court is quite particular. For example, like when it involves these voluntary causing harm, like to the causing bodily harm. So the courts are quite particular on this. They will also go for heavier sentence and punishment, use of force here. Okay, previous convictions. Okay, the person is a drug dealer and he has been in and out 5 times in the past 3 years. So this would be a very good aggravating factor put forward by PP. Okay, types of offenses. Certain types of offenses, for example, you see unlawful possession of firearms, bribery, drugs, and so on, even kidnapping and rape. These are too rampant, okay? And the court would want to deter people from committing these offenses, so it will also pass a heavier sentence, okay? Last but not least, the positions or status, okay? This one is a two-way sword, position and status. For example, you see, in this case of Datuk Harun Idris, the federal court actually enhanced the sentence because he was an MP and he should have presented good example as a leader. But in the case of Lim Kit Siang, see, the courts have actually reduced their sentences. So why I say it's a two-way sword is because of this. Okay. So for this, can Dr. Chee cover for the first page of appeal?
Can.
Yes.
I think you have to let me share, bro. I cannot share, bro. Why? Okay. Okay, for the appeals part, I think it's best for you just to do any question pertaining to appeal from subordinate court, for example, your magistrate court or session court to high court, because the statutes, what we call the CPC itself will contain whatever the provision that you need in order to deal with the questions regarding to this appeal, whereby the high court to court of appeal to FC, without good memorization of those CJA lah, IFC all that, better don't do. I think better don't do, because the provision must be exact. You cannot simply write IFC and put there finish, So I think we will focus on the appeal from subordinate court to high court, and then we'll look at the issues where subordinate court can appeal to court of appeal. I think these are the favorite question. Okay, first you need to know, and in your approach, you must know where is the source of power, the main legislation whereby the High Court can actually receive or hear an appeal from subordinate court. This is provided pursuant to Section 26 CJA. So this is your primary source, okay? And you must also cross-refer to Section 307 CPC, which provides any person who is not happy with any, the keywords here, any person, and also any judgment, sentence, or order pronounced by sub-court in criminal matter. So other than judgment, sentence, order, you cannot appeal. For example, in the previous year, past year question, there is a mention about ruling. So ruling is actually not a sentence, it's neither a judgment or order. It cannot be appealed. So get that in mind. Any person means the accused can appeal, the prosecution also can appeal. So please get that. And for you to appeal from sub-court to high court, okay, you must look at Section 304. Okay. Any offenses with fine punishment, that means money less than 25 ringgit cannot appeal. That is very important. Okay. Section 305 CPC. Okay. When the accused actually has a guilty plea, provided that guilty plea is UNCP, understand nature and consequence of that guilty plea. If there is no issue with UNCP, then the accused cannot appeal open the conviction, but the accused can appeal on the part of sentence. Remember, the judgment will be consist of whether the accused is found guilty or not, that means convicted or not. And second part of the judgment itself will contain or hereby punished with 10 years imprisonment. Take for example, I had an issue with drunk driving and I was got, and then under this Road Traffic Act, supposing now the punishment is very heavy instead of the normal one, usually first offender they'll impose 10,000 ringgit plus 1 day imprisonment. However, my case, they give me 25,000 ringgit and I plead guilty, 25,000 ringgit, as well as 3 months imprisonment, which is compliance. I mean, the court had passed sentence according to the law, so we cannot say anything. And I plead guilty already. So I cannot plead appeal on the basis that, oh, I want to overturn, I want to plead not guilty. Cannot. You can only plead and also appeal on the part of the amount of the 25,000, and also 3 months imprisonment is too excessive. Okay, remember that. And section 306, if let's say the appeal against acquittal of accused, for example, we take the case of PP against Sam Kerting. Sam Kerting was charged in sub-court and she got acquitted, correct? Subsequently, PP opened her acquittal, not very happy because she got released. Okay, so DPP must get the written sanction of PP for this sort of matter if the accused got acquitted on the court of first instance. Okay, so the case law will come later. Please be familiarized with all this section first. Okay, it is the section that you must use as your primary what we call authority. Okay, the case of Li Yufa if there is an issue with the UMCP, then you can argue, and then you can appeal for conviction and also sentence if there is a UNCP punya argument. So not very important here. Okay, so you refer to your section 307 subrule 1. Okay, first thing to do, in order for you to appeal, you must file in notice of appeal first. This serves as an intention that the defense wanted to appeal over the judgment. Okay, so this is like a notice of application or something like that. Okay, you must file within 14 days. If you expired, you can seek for extension of time from the court pursuant to your section 310. But better avoid this mistake in the practice. The court has its discretion not to allow the extension of the time, then you susah, when your appeal cannot go through, then you have to go for semakan, you have to go by the way of usul, your motions. Banyak susah ni. So please follow this time frame of 14 days. Okay, even though there is a provision of time, but this is entirely up to the court to decide. Okay, so this is the section 307 subrule. No formal form, but you must write it out and serve to the magistrate as well as to PP. Okay. And one more issue here is stay of execution. Okay, stay of execution is actually provided under section 311 CPC. Okay, normally, except for some high-ranking officer, usually there's no stay of execution here. Usually, they will fine you. You have to clear the fine on the spot, as well as you have to go to prison on the spot. Okay, unless you can prove some exceptional circumstances lah, to the satisfaction of court. This is if there is what we call fine and imprisonment. If there is a case involving whipping and death penalty, if there is an appeal, yes, you can ask for stay of execution. These are the two exceptions, whipping plus death. Okay. And subsequently, you need to wait. You need to wait for the ground of decision. This is going to be written by the judge. Okay. Usually, it will take about 1 month. It depends on how fast the court can provide you, as well as you need to get the notes of evidence. Okay. This is also the bundles of documents will be provided to you from the court side. Okay. So after you get this the judgment and the ground of the judgment, okay, as well as your note of evidence, then you can file in your petition of appeal, okay? And this is pursuant to your section 307 rule 4 and sub rule 5 as well, okay? And this is how to say, when the notice of evidence are available and also the ground of judgment available, then only you file in within 14 days. And same thing, don't miss the time frame. Otherwise, you will need to extend for time. Okay, the time for extension is provided under section 310. And I said before, it is up to the court discretion, so not easy. Okay. Subsequently, all these documents now you have record of proceedings. Okay, that means to say the juru bahasa will write everything pertaining to the prosecution witness, what he said in the court, what have the cross-examination and also the re-examination had done. You'll list down there's a bundle of documents as well, together with your ground of decision, as well as your notice of appeal, petition of appeal. Okay, you put it in the session court and sub-court, sorry, and then subsequently the sub-court will send to High Court PP for records. Okay, and then upon receipt of these documents, the High Court will actually need to decide whether they are preparing to hear your appeal or not. Okay, they can actually reject your appeal on the spot as well. Okay, so the hearing from the High Court is actually the submission, whether by oral submission or written submission on both sides. Okay, from the parent and as well as from the respondent. Okay, they talk, they argue on the facts, or they can argue on the law, why the accused should be convicted, why the sentences should be reduced. Take for example, okay, this is submission. They will never call any witness or give new evidence unless there is some exception. Okay, admissibility of fresh evidence could only be allowed in a very special circumstances. Okay, you can refer to the case of Luck against Marshall or R against Parks. Okay, there are actually a few criteria. I think you can see it here also. Okay, first thing, the evidence must not available during the trial. This is the first. I use a mnemonic, NRCR. Okay, NRCR. So evidence not available during the trial at the court of first instance, then you can use, okay? And it must be relevant to the case. And the evidence must not just be, it is relevant, but it is not so important to determine the issue of conviction as well as the sentences. Then it will not be credible. So the evidence themselves must be really credible, and also can cast reasonable doubt, okay, as to the guilt of the appellant. So favorite question, please remember R against Parks or Luck against Marshall. In Najib case, they use luck against Marshall lah. Okay, and subsequently, Section 318 CPC provided at the end of hearing of the appeal, usually by oral submission or written submission, the High Court will deliver the judgment in open court. Okay, open court. And Section 316 CPC is the power of High Court in doing so. Okay, in which the court may dismiss the appeal or actually reverse the acquitter. I mean, the acquitter can reverse it to conviction or find the accused guilty and pass sentence according to law. Okay, so that means to say there's two double-sided sword as well lah. If let's say, for example, we appeal my case, drunk driving case, I appeal on the sentences. Instead of getting lesser sentences, actually the court can impose a more heavier, a heavier sentence on me. Okay, that is their powers. Okay. And for High Court to Court of Appeal, I think you do not need to really go into details to memorize all that. But the one that is very important, usually they ask about the tiers, whether the case from magistrate go one level, High Court, can go to Court of Appeal or not. This is their favorite question. For Session Court, no problem. Must remember, pursuant to your section, this one, section 50, okay? Section 50 CJA, okay? Very important. If, let's say, this is an appeal from High Court to Court of Appeal, no need to ask for permission or leave from the court, okay? Court of Appeal leave, okay? So if let's say, for example, if it is from Session Court to High Court and then to Court of Appeal, also no need to ask for the permission from Court of Appeal, because Court of Appeal, not everything can go in one, So remember that, okay? It is an apex court for our subordinate court already, because 2 tiers of appeals, you got 2 chances, okay? So the issue usually they ask would be whether a magistrate court, the case from magistrate court, can subsequently go to High Court and then not happy some more, go to Court of Appeal. Okay, there are 2 cases, but if you cannot remember, you just remember the case of PP against Mahathir Mohamad. Okay, whereby it says that if PP is the one that appeal, okay, if PP is the one that appeal, you do not need to seek for any leave from Court of Appeal. Okay, that means you can go in directly. Okay, if the accused appeal, you need to get the leave. Okay, and if PP or the accused appeal, it only confined to the question of law. So this matter already set, If you have any debate regarding to the proviso, okay, you think actually this is a question of law. I think I have discussed the question of law and question of facts in the group. You have issue with the interpretation with CPC, with the DDA, with MACCA, with the interpretation of the statute itself. Yes, for magistrate court, you can go to Court of Appeal. Because Court of Appeal very busy. They will not entertain, usually they will not entertain question of facts. Because reason is very simple. Appellate court usually do not and rarely interfere with the facts finding made by the judge in the court of first instance, because judge at that moment of time will see witnesses, how they behave, their demeanor, the manner being cross-examination. So the Court of Appeal judge will only see the paper of your submission, So whatever jot down by so they won't entertain much. Okay, just remember that. The rest, I think seriously, just I think should I use the word let go, bro? I think very hard Even practitioner also we refer, isn't it?
Definitely. I think better what Dr. Chee has said is definitely correct. There is no need for you to go into detail the others, because first of all, during examination, you might be panicking, you see. So yeah, you might not be able to engulf so much. Yeah.
Yeah, these two very high tech one, so better don't lah, better don't lah. Spend some time, get familiarized with the whole CPC is even better, You are more, you are more safe to do so.
Correct, definitely. I agree with Dr. Chee. So I think
So,
yeah, bro. I
this
I
part
will, I
you
will
could
I cover the high court revision.
okay. This part, okay.
Yeah, you go first. Yeah.
Okay, like I just said to you, the appellate court, that means the court that handle the hearing of appeal is actually based on submission. They will not review weaknesses, they will not review what we call the new evidence, etc. So in this particular manner, they hardly interfere with the conclusions of the trial in regards to the facts. So this one you must remember lah. Okay, primary principle, remember first, then subsequently you just memorize for the sake of examination. You just memorize one or two case enough already. Okay, to cite the authority. Okay, understand the principle first. Okay, so if let's say it is against the acquittal, I use the case of PP against Samketing here, whereby he got acquitted in the sub-court, okay, and then subsequently PP appealed to High Court. High Court, she got convicted, correct or not? So we look at the first court of first instance against acquittal. So this case, I think you must remember the Shio Sharuk against Crown, okay, where the Privy Council said in reviewing the acquittal, because acquittal means the Samketing should walk free, from court. Okay, so how is the view? Okay, so the view of the trial judge must see the credibility of the witness, and they give presumption of innocence to the accused, because accused got acquitted in the court of first instance, and they will also give benefit of doubt to the accused. And actually, again, this one I emphasize one more time, appellate court is very slow and rare to disturb the finding of facts done by the subordinate court. Okay, and what about against sentences? Okay, take for example, who can be made an example? PP against Datuk Seri Muhammad Najib. He was found guilty and convicted in the High Court, correct? So appeal. So what is the attitude or principles that must consider by Court of Appeal? So the Court of Appeal cannot alter the sentence merely because the members of the court must have passed different sentence. He cannot compare with other people that commit similar crimes with him. Why I get 20 years? He get 10 years. I cannot. So this is the first principle. Okay, if you want, you can use the PP against Leonard Glad Francis. Okay, and the appellate court cannot impose a sentence which exceeds the jurisdiction of lower court. This one is very important because you know why? Subordinate court, for example, magistrate court, maximum jurisdiction is only 5 years. But when you go to High Court, the law said that the High Court can actually impose can vary, alter, or impose heavier sentence to the accused, but they cannot go more than the one that under the sentencing jurisdiction of magistrate court, So magistrate court only 5 years, the case come to High Court. You cannot use the unlimited jurisdiction of High Court. Okay, I give you 7 years, cannot. So must be still within 5 years, important. And another principles I think would be in case of Chu Cheng Liu, if the appellant passed away during the pendency of the appeals, his appeal should be abated under section 320 CPC. Okay, it only apply to the appeals from a sentence of fine or competency order of sentence combining the substantive imprisonment with fine. Okay, that means to say, how to say, let's say during the appeal, by right, the person should impose with 2 sentences. Okay, I take another example of mine. Drunk driving, 25,000 as well as 3 months imprisonment. Let's say touch wood, I die in between the appeal. Okay, I did not serve any imprisonment yet. So which one will go away? The imprisonment 3 months will go away. The 25,000, my estate still need to pay, you know. You get me? So this is pursuant to your section 320. In fact, a better case for you to remember will be PP against the estate of Kappa Singh. Kappa Singh had a case, I don't know what case already, and he passed away. Yeah. So that's all from me. Hey, bro. Yeah.
Thank you, bro. Can you please slide it over for me only, just the High Court power? I'll just go through a bit. Yeah, thank you so much. Okay, so when it comes to this High Court power of revision, I get a lot of questions. How is it different from an appeal? Okay, this High Court having an inherent power of revision, meaning that the purpose, as you can see, is to correct or prevent miscarriage of justice, which may arise from error in judgment and procedure. Okay, the case would be Hari Ram Segal. Okay, this is not an appeal to keep in mind. It is merely a High Court invoking its powers to look into the matter. Okay, so I get another question would be, how can you actually apply for this kind of power? Okay, first is the subordinate court, for example, the Sessions Court, informing the High Court about its doubtful about this decision. The second one, it can be what? No, it can be by any letter, unsigned or undated. You just post it. It can also make the High Court invoke its power to revise the case. Okay, another one would be the High Court itself. Upon looking at the news, upon looking at the newspaper whatsoever, it invoke itself, you know. This can happen also, okay? And one more type would be detention, date in custody. So the High Court might invoke the powers as well for date in custody matters. Okay, so let's look at this here. Okay, section 325. 325. These are the powers of judges on revision. They can stay the execution, arrest the respondent. However, keep in mind that it cannot overturn an acquittal. Okay, cannot overturn an acquittal, meaning that the person has been granted DAA, has been acquitted. So the High Court couldn't ask the accused back saying that you are now acquitted. It's not allowed here. But it can quash a conviction. Okay? So regarding this quashing of a conviction, we refer to section 326 as well. Okay. You see, 326 saying that whether the question will be whether the parties should appear. Okay. Okay. The last question there, 326. However, normally no need to appear. But there is one rule called the Odi Alteram Partem rule, meaning that no man should be condemned unheard. Okay? So for example, you see, this accused, this High Court actually invoked the revisionary powers. Okay? Now, the PP is not there. And the accused also didn't attend. Okay? And the High Court quashed the conviction of this accused. So can this quashing of this conviction stand? The answer, you can refer to the case of this PP against Muhammad Tarmizi. I believe it's not in the notes. PP against Mohamed M-I-Z-I. Okay. The federal court said that any person to appear in this, as per this section 36 of the CGA 1964, would include the prosecution. Okay. So meaning that if the accused was present, and the prosecution was not present, and the court quashed the conviction, this is actually not legal, meaning that this quashing of this conviction was illegal. So what happened? The FC actually was ordered to be back, for the case to be back to the magistrate's court for a retrial. Okay. So this might be some of the factors you might need to look into. Okay. And just now I've mentioned about how High Court could actually invoke their powers. Okay. And it's worth noting in the case of this Hari Ram Segal, which we quoted earlier, this case has no notes of evidence and grounds of decision. Okay. The accused actually sought the revisionary powers of the High Court. Okay. So the conviction was of course quashed. But subsequently, during the appeal, due to there were no record of the proceedings available at that point in time, so the High Court actually couldn't exercise its revisionary powers to acquit and discharge the said accused without ordering for a retrial. So as you can see here, these revisionary powers is actually not an appeal. Okay, it has its limitations as well. Okay. I believe that's all. One more thing to add on. As you see, this is a revisionary power as mentioned. So let's go to section 327. The revisionary notes are final. Okay, meaning that because it's not an appeal, it's a revision. Yeah. So yeah, I believe that's all for these High Court powers of revision from my side. So we can open up the floor for Q&A session. I think it will be easier for you to press the raise hand button and you just on the mic because I believe everyone here is quite tired already. So we would like to. I'm okay. Just that I worry that the students, the candidates might want a rest. So yeah, can we open for Q&A now? Maybe you get
Actually, you all
about
can ask, you all can ask in the group as well, don't be shy because we receive quite a number of private messages, which I think frankly a little bit this one hard for us to attend one by one. You all can ask in the group, There are senior lawyers some more in the group.
yes. So we open for about 15 minutes. Max until 11, we can answer some questions, probably. Just one question. Are we going to do special proceedings? What do you mean by
Inquest.
special inquest?
Inquest.
Inquest, I don't think we are going to cover that.
Inquest you
all
want to do, I just attended a course from Bar Council. Remember the inquest course? Actually, the notes were a bit outdated. We now refer to the practice direction. The practice direction for inquest. And now we have a session court judge that is a president for the coroner's court rather than magistrate court. That was spoken. If they want, I can have a small session in our next lecture for inquest. Very specialized topic.
Is I believe it will be for this.
Yes, it's practice
our-
direction number 2, 2019. Yes.
Okay, for the revisionary power. Okay, just
The Muhammad
just
Tarmizi, is it?
I type lah, never mind.
Okay.
So we are glad that we have covered all the CPC matters.
I think from today onwards, they must flip through CPC, ROC, all the statutes available. The important statutes, you must, I think you must go to bed with those statutes, This is how we did in our previous attempt. Oh, there's a latest case of PP against Rahmat Ghazali. Oh, then I need to check Kritina.
Thank you for letting us know, because
Yeah.
sometimes we are also outdated lah. Thank you so much. Thank you so much.
Yes. Because based on literal interpretation of this section 50 sub-rule 3, it memang stated the question of law only. Is it from magistrate court? That one I need to check, Session court, we have no issue. You can go from high court and also court of appeal, no need leave. But magistrate court is the one that issue lah. So the PP against Rahmat Ghazali had fall back to the Kanaga Sabi, Pasupati case. This one, Pasupati Kanaga Sabi. This one we need to check. Then we put it in the group later lah.
It was a view of abolition of death penalty, penalty penalty. This one, yeah, everyone has their own personal opinion. If it's for the accused, it's of course good lah for the family of the accused, because the son or daughter is actually not going to die. But for the victim's family, it probably otherwise lah, I believe. Yeah. What do you think, Dr. Chee?
I think almost the same lah. Very
Subjective,
hard
right?
to resolve, and very hard to reconcile in between the two parties lah.
So we have about 20 over days left to this CLP. So just I believe health is important lah. Just get enough sleep, get enough vitamin C and so on, drink more water. Really, not how are you going to perform, right? Can ask us anything lah. We stay till 11, right? Can
You're quite tired already lah, properly. Yeah, it's like that lah.
Dr. Chee and Mr. Gan.
Hello.
Yeah, I got one question. I read somewhere,
Yeah.
but I clarify the answer of this. While in appeal exercising revisionary power, how shall we see about this? High Court.
Okay, can you come again, the question? I didn't hear you clearly.
While High Court exercising its appeal, hearing the appeal, can the High Court at the same time use its revisionary power?
Okay, for this, meaning that you mean that the High Court is actually hearing the appeal, but at the same time invoking its revisionary powers, is it?
Yes. I read, but I couldn't read somehow.
Okay. This one, right?
To me, this is
Yeah, Dr. Chee, you can go first.
no, it's okay.
I have one of these, what we call that, statement regarding this, but I need to search for a while. So Dr. Chee can go first, maybe.
Invoking the appeal in revisionary power. Revisionary power, usually you either go with appeal or revision, you know. Okay, revision, the powers usually, if appeal is not possible, okay, for criminal matters, whereby it falls into usually ruling law, like I said, ruling, and some of the cases love to go for revisionary powers would be like you have those inquest case, like the case of Coogan, Teo Peng Hock, they all go for revisionary power of High Court because they were not happy with the verdict met by the coroner's court. So in my personal opinion, it doesn't come combined together, you know.
Okay, doctor. Okay, thank you.
I would like to refer to the case of this Muhammad Dalla bin Rizwan against Dato Bandar di BKL. It is stated that these revisionary powers of High Court shouldn't be resorted unless in very exceptional cases and for very good reasons. Meaning that if the decision of the subordinate court can be appealed but was not appealed, they are slow to interfere with their revisionary powers in the case of Muhammad Dalla bin Rizwan against Datuk Bandar di BKL by the late Justice Gopal Sri Ram, Dato Sri Gopal Sri Ram. Yeah. So I can write the case here, you can have a read. So meaning that if it's appealable, you go for the appeal instead of revisionary. Yeah.
Thank you, Mr.
So no more questions, I think.
Yeah.
Yeah. So if there's no more questions, we'll end the session here. Thank you, Dr. Chee, and thank you everyone for your precious time.
Good luck to all of you. Good luck.
Yes.
Seriously, good luck.
Yeah. Thank you so much. Have a good rest. Have a good rest, everyone.
Yeah, thank you, thank you. Please go and have some rest. It had been a long
Yeah.
day.
Definitely.
Thank you.